and welcome everyone. Thank you so much for joining us today. My name is Denise and I'm part of the investor education team here at Scotiatrust. Today's conversation is all about building awareness and understanding around estate planning, what it is, why it matters, and how it connects to your broader financial life. Now, while estate planning is often thought of as something to deal with later in life, the reality is that it's simply about being prepared. It's about understanding how decisions today can shape clarity, efficiency, and outcomes in the future for yourself and for the people who matter to you the most. And to help guide us through this important topic, I'm very pleased to be joined by Alicia Mossington, estate and trust consultant at Scotia Wealth Management at Scotiatrust. Now, she works closely with individuals and families to help navigate the broader considerations of estate planning, from understanding wills and powers of attorneys to thinking through executorship, trust, and how estate planning intersects with financial planning, investments, and all that good conversation. So today we're going to walk through the structure as well as some key roles that are involved. And as always, this discussion is going to be for education purpose only. So not legal or tax advice, but really here to provide that general conversation to all of our audience. With that, I'm going to hand this over to our guest speaker. Alicia, welcome. How are you doing today?
I'm doing very well. Thanks, Denise. Thanks for having me.
Absolutely. Very excited to get this topic rolling. It's the first time ever that we're presenting a topic like this to Scotia iTrade. So thanks again for joining us. To start it off, I'd love it if you can just share a bit about your role as an estate and trust consultant and the types of estate planning situations you're commonly exposed to.
Yeah, super. Well, as an estate and trust consultant with Scotiatrust, we primarily work with clients that have complex needs or circumstances. Those might be clients that have more detailed or require a more in-depth approach to the wealth transition component. Now, that's not necessarily limited to the ultra wealthy. I would say many of our clients are affluent Canadians that have unique circumstances, circumstances where we might need to dig a little bit deeper. That might be complex family structures, such as second marriages. That might be folks with stepchildren or beneficiaries that have a need for some additional support or protection. The Bank of Nova Scotia Trust Company, and I'm going to call it Scotiatrust for short, is a federally incorporated trust company in Canada. Now, as a trust company, we're authorized to act in a fiduciary capacity, and that's most often where Scotiatrust might be named as an executor, a co-executor, maybe as under a power of attorney for finance or property, or as a trustee. Many individuals might not be aware of us, but we are part of the Bank of Nova Scotia, and through predecessor companies have been working specifically in this area, estates and trusts, for more than 100 years. So we've seen a lot.
That's amazing. Thank you for sharing. From your experience, what would you say some of the most common misconceptions people have about wills or estate planning more broadly?
Yeah, that's a good question. There are a couple that come to mind. I think, first of all, many people believe that they have a simple estate or only need a simple will. And then the second common misconception we find is that people may not feel they need a will at all. Now, in our experience, there's no such thing as a simple estate. What we don't want is we don't want convoluted. Straightforward and clear are good hallmarks of a comprehensive estate plan. But a comprehensive estate plan really should take into account someone's wishes, their assets, the ownership structure. And again, I think what we want is a straightforward plan, not a convoluted plan. And straightforward doesn't always mean simple. Now, the second misconception being that, many people believe they don't need a will.
Mm-hmm.
There are different rules in different jurisdictions. In some areas of the world, legislation governs the distribution of an estate. And this might be why people feel they don't need a will. But in Ontario, specifically, and Canada more broadly, we have a lot of testamentary freedom. So that means your will is a really, really important part of the plan.
Now, Let's set the stage a bit for someone that might be brand new to this topic. How would you explain the difference between a will and an estate plan?
A will is a legal document that sets out our testamentary instructions. There are different types of wills that are recognized across Canada, but generally a will is a document that's going to do two things.
Mhm.
Your will is going to appoint your executor, and then the will is going to outline how you want your estate to be distributed. The will is the cornerstone of an estate plan. It's a very important part, but it's not the whole thing. Um, when we say different assets have different planning considerations, some of those assets might be governed by the will, some of them will not be. And the will is not the only document that forms part of the estate plan either. Generally, there would be three different types of documents that we might see. We would see a will, we might see a power of attorney for property, and then we might also see the power of attorney for personal care. And those documents do different things. Okay, and then taking it back, I had mentioned, the will allows us to name our executor. The will allows us to outline how the estate is going to be distributed. And I mentioned that different assets have different planning considerations. Just wanted to give an example of what I meant by that. A good example that I often use would be registered assets. So for example, someone might have an RRSP, they might have a RIF, you might have a tax-free savings account, or even life insurance. And those types of assets are unique because you can designate beneficiaries. If you've designated a beneficiary or multiple beneficiaries on those accounts, the money that's in there generally would be paid out to the person or people that you've named. Those accounts then may not form part of the estate. They might not be governed by the will. So we want to make sure that we have those documents in place, but the broader estate plan is going to take into account those unique differences with different types of assets.
Thank you so much for clarifying that. I'd love to explore the estate planning a tad bit more. Why is estate planning often described as more than just deciding how assets are distributed, more than just deciding who gets what?
Yeah, at Scotiatrust, our approach is a little bit different. So we take more of a holistic approach to estate and wealth planning. A comprehensive estate plan should account for who gets what, but there are other things that we want to think about. For example, the choice of the executor. The executor is, that's a big job. It's a lot of work. It's a lot of responsibility. So we need to think of who are we going to appoint in that position? Do they have the time to do that job? Do they have the expertise to do that job? We also want to think about our specific beneficiaries, who those folks are going to be, if we need some additional instructions or support around how an inheritance is going to be transitioned to that person. And then the other piece that we want to look at sometimes for estate planning is minor children. We have beneficiaries with unique needs, particularly for minor children. We might need to name a guardian or multiple guardians. So those are different facets of an estate plan that we want to take into account.
Now, this is going to be a little bit difficult because it is quite a personal question, but at a very high level, what generally happens if someone passes away without a will in place?
When someone dies without a will, it's known as dying intestate or an intestacy. And the rules governing intestate succession really depend on the applicable province or territory where the deceased lived. And then it also depends on where the assets are physically located. In Ontario, which is where I'm based, we rely on a mix of provincial legislation and then also the common law. Remember that ultimately the will lets you name your executor, and an executor gets their authority to do that job from the will itself. Generally, if someone passes away without a will, that means that there's nobody specifically authorized to act as an executor. So someone's going to need to apply to the court for that position. In Ontario, we call that application process applying for a certificate of appointment of a state trustee without a will. It's a bit of a mouthful. And in Ontario, there's some legislation that sets out who is entitled to do that job. Again, if someone passes away without a will. If there's no will, we also don't have someone's instructions about how they want their estate to be distributed. So again, there's a piece of legislation that is going to impose how the estate gets distributed. So in a nutshell, really important to have a will.
Thank you for setting that stage and that foundation. I think this question often comes at our thoughts, and now we have an idea of the importance of it as well as the details that follow that can happen with or without that will. I love to dive a bit deeper in terms of the key documents and roles. If you could just walk us through the key documents people often hear about. So, for example, you've mentioned wills, you've mentioned power of attorney, trust. How does that all fit together? What purpose does each one serve within this big overall plan?
That's a great question because they all do serve different purposes.
Mm-hmm.
Um, the will really applies once someone has passed away. So the last will and testament, again, it allows you to name your executor, and then it allows you to outline how you want your estate to be divided. So the will itself, we want to make sure that we have it set up. Then it's going to stay in the drawer until we need to use it. Powers of attorney are separate documents that allow you to name or appoint a substitute decision maker if you're not able to make decisions while you're alive. And I want to really highlight the importance of powers of attorney because we talk about wills a lot. I think most people are kind of familiar with the concept of wills, but powers of attorney are, in our experience, something that a lot of people do not have in place, or it's a little bit more of an afterthought when we look at estate planning. Wills are important. Powers of attorney, again, allow you to name someone or several people who could make decisions for you if you're still alive but aren't able to make decisions anymore. We generally see two common types in Ontario. We would have something called a continuing power of attorney for property. So that's the first one. And that lets you name someone or several people who could make decisions about your property, about your finances. It's a very, very powerful, very all-encompassing document. And then the second document is something called a power of attorney for personal care. Historically, that might have been referred to as a living will. Now we call it a power of attorney for personal care. But that would involve decisions around health care, even things like nutrition, clothing, shelter, so where someone lives, that's a personal care decision. Also decisions around consent to treatment or withdrawal of treatment. So we've talked about wills, we've talked about powers of attorney. The third piece of an estate plan that we might see are trusts. And trusts are structures that might be established while someone's alive, or they might be established through a will. And a trust that someone sets up while they're alive is called a living trust or an inter vivos trust. A trust that someone sets up in a will is called a testamentary trust. And that's the most common in my experience with the clients that we work with. Trusts in a will might be included for a variety of reasons. We might see a trust in a will used to transition an inheritance to someone who's quite young. If you have a beneficiary inheriting $1 million, maybe you don't want that person inheriting $1 million at age 18. Maybe we want to bump the age up a little bit. Maybe it's 25 or 30, for example. That would be an example of a type of trust structure that we might see in a will. So trusts in a will allow you to put some instructions for how and when an inheritance might be released or how an inheritance might be managed over time.
Okay. Now, Alicia, another common role that we might often hear is an executor. How would you describe the role of an executor, and what are some of the responsibilities associated with that role?
Well, we've been using the word executor this whole time, so I'm glad you asked that question because I am mindful that sometimes we use the language interchangeably. You and I have been using the word executor, but folks might also see the words estate trustee or trustee used. And generally in Ontario, we do use that language interchangeably. It's quite similar in some of the other provinces and territories in Canada. I'm going to stick on using the word executor because that's what I'm used to. But think of the executor as the manager of the estate. Really, that the executor is responsible for paying debts, paying taxes, any final expenses. They have to protect and identify and collect all the assets that form part of your estate. There's 100 other tasks that the executor is responsible for completing. And being an executor is a very big job. As you can appreciate, it's going to take a good amount of time to fully settle the estate. And that's especially true for someone who might be doing that job for the first time. They might have family, personal, professional obligations. So choosing the executor is a really important part of the will. Executors are also personally liable for the job that they complete. They are responsible for those tasks that I mentioned, paying debts and taxes and final expenses, but they also owe a fiduciary duty to the beneficiaries. Ultimately, they have to act in their best interest. And just to kind of expand on some of those tasks that the executor might be responsible for, that might be obtaining valuations or assigning values for different types of assets. That might be selling or renting or mortgaging assets like real estate or commercial properties. The executor might be responsible for directing the management of investments. They might manage personal or household contents. That's a big one, including vehicles, jewelry, artwork, boats, trailers, those sorts of things. And then they're going to need to prepare and file outstanding tax returns. And there's some other reporting and filing obligations as well. So not a small job by any means, but that in a nutshell is the role of the executor.
Okay, let's connect it over to our audience today. We're here with our self-directed audience who is connected to investing. How would estate planning intersect with that broader financial and investing plan conversation here, Alicia?
I think they dovetail really nicely. I think those two conversations are important to have, and it's important to have sometimes those conversations together. When it comes to wealth, financial benefits are very important, but family harmony is invaluable. And sometimes these challenging conversations, the most challenging ones are often the most important ones to have. Remembering again that different assets have different planning considerations. And this is true about estate planning, just like it is with investment planning or financial planning. We often will work with financial planners to build out a financial plan. And that financial plan is going to include part of the estate plan, but it's also going to look at different scenarios and their impact on investments, as well as the estate planning. So for example, I had earlier mentioned, unique assets like RRSPs or RIFs. Those have certain nuances from an estate planning perspective, but there's also different income tax consequences for those different kinds of assets. So a financial or an investment plan might look at planning strategies during life. That plan might look to mitigate some income tax consequences on death. And then, look at how we distribute those assets as part of the broader estate plan. So it's interconnected.
I see that. And I like how you've mentioned a couple of the investment accounts before. What's the importance to understanding how these different investment account types are treated in an estate context?
Yeah, well, I've alluded to kind of the different tax implications for those couple different accounts, but there's other differences to be aware of as well. Again, going back to my example of RRSPs, tax-free savings accounts, life insurance, I mentioned those accounts are unique because you can designate beneficiaries on there. And when a beneficiary is designated, remember that the money that's in there generally is going to pay out to the named beneficiary. And that can be a good thing, but that can also cause unintended consequences for the broader estate plan. So for example, let's say you have 5 beneficiaries that are named in your will, but you've designated 2 beneficiaries on your TFSA. Well, those two beneficiaries will receive perhaps the money that's in the tax-free savings account, and then those other beneficiaries in your will are not receiving that money. So again, that might be a good thing, but that might be an unintended consequence. So we want to look at the big picture, make sure that the assets are set up in line with what ultimately your wishes are for your estate.
Mm-hmm. I see from our conversation so far, we've definitely talked about the importance of one for those of us who may not have one started yet. Now we can see the preparation process. But some of us may be in the scenario where we've already started a will. Let's say we've made one up back in the 2000s. Do I need to update it right now? What are your thoughts on that?
Mm-hmm. Wills themselves can be valid and legally enforceable for a really, really long time, but changes in your life or changes in the lives of those around you might trigger the need to update the will. So, for example, if there's been a new birth, if there's been deaths, if there's been subsequent marriages, those might be reasons we want to revisit the will. Your assets might have changed over time as well. You might have acquired or sold different types of assets. You might also now own assets in different jurisdictions. That could be a reason why we need to revisit the estate plan. There might have been changes in your life from a marital perspective. You might have gotten married, you might have gotten divorced. Those might be reasons to revisit a plan. And then there might have been health changes as well. So we want to take those factors into account when we're looking at an estate plan. I would say generally a good rule of thumb would be to review the estate plan every 3 to 5 years. Although your will might be legally valid and enforceable for a very long time, these different types of events do happen. So it is important to take the plan out, have a look, make sure it's still going to do what you want it to do. And we find that 3 to 5 year benchmark to be fairly helpful.
I agree, especially if you mentioned there are so many different scenarios that could happen if we've made our will a long time ago. And one thing that you've talked about in your response is increasing asset complexity, multiple accounts, properties, businesses, impacting all of that, impacting estate planning considerations. How can all these scenarios impact it, and how should we approach that?
Yeah, so one example I would give, and a conversation that comes up fairly frequently with our clients, are located in different jurisdictions. You know, someone might have purchased a property outside of Canada. Maybe it's a second home, maybe it's a cottage, for example. Different jurisdictions have different rules, and it is possible for someone to have multiple wills. You might have a will in Canada, you might have a will elsewhere, and it is very important that those documents complement each other and don't contradict each other. It is possible that one will could cancel out another one. So we always want to make sure that we're talking to the lawyer that's preparing those documents, sharing all of that information, especially when we have a few different legal jurisdictions involved. We want to make sure that the plans work together and don't cancel each other out.
And like you said, it's all about that complement. So I like that. Thank you so much for trying to explain all this in such a short time frame. I'd love to wrap things up and share some final thoughts. What is one high level insight you think is important for investors to understand when thinking about planning ahead?
Ultimately, estate planning is about life. You know, everyone needs a wealth transition plan, and some people could benefit from the services that Scotiatrust offers. Our team is highly experienced. We're hands-on professionals. We help executors, or we might act as executors, but not everybody needs a trust company. We do work with a diverse range of clients through very important and sometimes challenging conversations about life and legacy. And all the hard work that you put into creating your wealth shouldn't be undone because you're not prepared. You can plan ahead. You can plan ahead to ensure that your wealth lives up to its intended purpose and that your wishes are followed both through and beyond life. And really, one of the best ways to do that is with an estate plan. that's my takeaway.
Thank you. I'd love to also share a couple of takeaways for our audience as well. For those of us who are looking to explore more of this topic or just keep on track or understand it a bit more, I know today's event does not cover everything, so I'd love to share a couple of resources we can take away. I'm sharing with us our enriched thinking, where we can take a look at additional articles and resources and different stories that can help us through the scenarios that we might be looking or might be experiencing. You are able to explore this on your own, and you'll find hopefully one or more than one area that's going to match your interests and be able to guide you through there. Additional part is this site where it's called Connect with Us. And as much as we love to keep Alicia in our pockets, we don't have that lovely capability. So what I would love to leave us with is this additional connecting piece where you're able to have more of a self-serve option to connect with the ones that can share a better insight on your scenario.
The Connect with Us feature is a great way if you have specific questions, or you want to speak with an estate professional at Scotiatrust, or just learn more about Scotiatrust and what we do and how we might help. This Contact Us portal is a great resource. We have estate and trust professionals located across the country, so the Connect with Us portal will allow us to put you in touch with someone who is going to be able to address what you're looking for, where in the region where you are located.
Thank you so much. Really appreciate you tackling all of these hard but heartfelt questions from our audience and ourselves. And hopefully we'll get to see you back soon again on this platform. But thank you again.